Ladies and gentlemen, as was promised at our last program on absenteeism, I promised to give you some industrial court judgment concerning absenteeism, and I mentioned 3 judgments in particular. One to a dispute number 159 of 1974, ESD, Essential Service Division, number 16 of 982, and the third one, HCM, High Court Matter, number 3015 of 1987, between Bernadette Caesar Hood and Attorney General and Minister of Economy. Concerning trade dispute number 159 of 1974 between Cannons Limited and NUGFW, that is the National Union of Government and Federated Workers Trade Union, this judgment goes to the root of absenteeism. Credit must, however, be given to the late Emile de la Grenade, who was a consultant and industrial relation officer as well as credit unionist, who presented this case for Cannons Limited at the Industrial Court. The principle which Mr. La Grenade presented and was accepted by the Industrial Court was follows. 1. The worker who has absented himself from work with or without a medical certificate can be disciplined. 2. If a worker absents himself for 2 days per month for 9 months consecutively, he can be dismissed from work. That is extremely important to employers. However, the matter of this judgment indicates that, as was stated by Professor Bayer, from whom Mr. La Grenade got the information, stated that the employer is obligated to inform the employee before he takes such action. Thus, you must use your statistics or your records to deal with the worker, informing him unless he changes, action will be taken against him. Equally important is the judgment handed down by the court known as ESD number 16 of 982 between T&Tech and OWTU. This judgment that the famous lady gave, the judge, Justice Lady Riley Haynes, stated several principles. Number 1, when a registered medical doctor is writing a medical certificate, he must not do so for the worker, but must do so to satisfy the employer. This means that the employer could challenge any time that medical certificate if he is dissatisfied, whether there's a confidential relationship between the worker and the employer. The employer has that right to do so. It goes on. A medical certificate refers to a document from a medical practitioner certifying that a person is suffering from physical, mental, nervous, or other illness and recommending or purporting to recommend that some period of time should be spent away from work on account of the illness. Therefore, when a doctor sends a medical certificate to an employer saying that the worker is suffering from a medical problem, that must be challenged. Thirdly, a medical certificate should include the facts of the examination and the diagnosis if it is such that these findings can be confirmed by another examination or otherwise. If not verifiable, that the certificate should reflect that reference was made to the applicant's medical history and that the diagnosis was in keeping with such. What this is saying, that you, the employer, can ask for a second examination. You could go to another doctor to confirm or disqualify what was said by the previous medical doctor. More importantly is the judgment HCM number 3015 of 1987. The credit must be given to Ms. Bernadette Caesar Hood, who has been backed up by the Public Service Association. This judgment gave the principle saying that a worker's job is her property and can only be taken away by due process of the law. Ladies and gentlemen, as a result of this judgment, you must be careful when dismissing a worker, especially for absenteeism. The worker's job is his property. In order to get rid of that worker legally, you must use a process, and the best process is the progressive steps of discipline. Thank you.